So welcome to the All About Age webinar. This year, Gowling WLG's Combined Human Resource Solutions team has been marking the 10th anniversary of the introduction of age discrimination legislation with a whole series of events. And today's webinar comes just after the 10th anniversary of the introduction of the age discrimination exemptions for pension schemes. I'm Ian Chapman-Curry, a Principal Associate in the Pensions team at Gowling WLG, and I'm joined today by Liz Wood, a Director in the Combined Human Resource Solutions team. Hello again, Liz.
Hello, Ian.
And I'm also joined by Ruth Ormston, a Principal Associate in the Combined Human Resource Solutions team. Hello, Ruth.
Hello.
So today's webinar will last for about 45 minutes, and I do appreciate that we are starting late because of those technical difficulties to start with, but we will still have time for questions at the end, and like we said, we'll make sure that you get a recording and we'll respond to questions that come in from you. So just a few brief housekeeping points. The webinar player has a few simple controls, which I imagine many of you have been struggling with, the volume adjustment and the full screen option in the bottom right-hand corner of the player. Hopefully those are all resolved now. We've had confirmation from the provider that things are working. You can ask questions at any time. Just click on the Ask a Question tab, type in your question and click Submit. And we're going to try and answer as many questions as possible in the time available. We'll also be encouraging a bit of audience participation through a couple of polls that will automatically flash up on your screen. And now over to Liz.
Thanks, Ian. So, as Ian mentioned, today's webinar is designed to provide an update on the age discrimination legislation to the extent that it impacts on pensions. And there's no doubt that this remains an area rife for potential claims. I think this is for several reasons. It's partly because of the way the law is written, which means that some otherwise discriminatory acts are excluded, but some are not. Partly because it's common for employers to have different pension benefits in place for different sections of the workforce, reflecting the way in which provision of pensions and other benefits has evolved over time. So, for example, it's more common for older employees to benefit from defined benefit pensions, whilst individuals who are now starting work for the first time are likely to only be offered defined contribution pensions. Finally, because pensions in particular can be seen as inherently discriminatory, because on a simplistic reading at least, they're structured so as to benefit older rather than younger workers. Today we'll provide a brief overview of why we have age discrimination legislation in the UK, a reminder of the types of age claims that can be brought, an update on how employers and trustees can defend themselves against age claims, including consideration of some of the tricky areas, before ending with some practical tips for employers and trustees of pension schemes. So why do we have age discrimination legislation in the UK? Well, a 2000 European directive established a general framework for equal treatment in employment and occupation. And this directive looks at a number of protected characteristics such as religion, belief, disability, age, and sexual orientation. Member states were required to introduce legislation which complied with the framework, and the age aspect had to be introduced by the beginning of December 2006. So the UK government introduced the age discrimination aspect governing employment in October 2006, followed in a last-minute flurry by the pensions aspect on the 1st of December 2006. And importantly, in terms of what we're talking about today, whilst it was originally expected that there would be a wholesale exclusion in the legislation in relation to pensions, the government instead issued provisions which contains a number of listed exclusions relating to what would otherwise be discriminatory provisions commonly found in pension schemes on age grounds. Mainly, there was no blanket exclusion. And the age discrimination legislation is now found in the Equality Act 2010 and the very catchily named Equality Age Exemptions for Pension Schemes Order 2010. So why is it important to be aware of the potential for age discrimination claims to arise? The first reason is because of the way the age discrimination legislation is written. Everyone has an age, and the protected characteristic of age is very widely framed in the legislation, which means there are lots of different ways in which an age claim can be brought. It's not just open to older employees, but to employees of any age, and so younger employees could quite feasibly structure a claim that they have been discriminated against by comparison with older employees. A good example is the case of McCulloch and ICI. Here, ICI was undertaking a redundancy process, and Ms. McCulloch, the claimant, aged 37 at the time, was made redundant and brought an age discrimination claim based on the structure of ICI's redundancy policy, specifically the redundancy pay that she would receive on being made redundant, which was calculated based on the individual's age and length of service. And Ms. McCulloch said that she was being discriminated against by comparison with both younger and older employees. So it's quite a good example of essentially how even a middle-aged person can bring an age claim. This means that employers and trustees should at least attempt to anticipate where an age discrimination claim might come from. Employee claims are always expensive for employers or trustees to defend, but unlike other employment claims, such as unfair dismissal, there is no cap placed on the award an employment tribunal might make in the face of a successful age claim. This immediately becomes a more stark proposition for employers and pension scheme trustees who are considering whether any of their practices are discriminatory. Age discrimination issues are also potentially expensive to make good. For example, if an employer's redundancy policy is found to be discriminatory on age grounds, or if the pension scheme rules are found to have age discrimination issues, this could be very, very costly for the employer and or the pension scheme in question. And finally, there is a direct obligation under the Equality Act 2010 for both employers and trustees of occupational pension schemes to get this right or to face claims. Bearing all this background in mind, Ruth's going to now give you a reminder of the types of age discrimination claims that can be brought.
Thanks, Liz. Well, we thought it'd be helpful before we sort of delve into all of the details on pensions, just to go back to basics and the starting point and look at what do we actually mean when we talk about age discrimination, what is prohibited. And the main provisions concerning age discrimination can be found in the Equality Act 2010, and that prohibits a number of forms of discrimination. The first one on the slide here, direct discrimination, occurs where there's less favourable treatment towards somebody on the grounds of their age, and that might be a specific age or an age group. And so normally here you require a comparator or a hypothetical comparator who's of a different age or age group to see whether or not there has been less favourable treatment. We then come on to indirect discrimination, and I think this can sometimes be a little more tricky for both employers and employees or members to spot, and this will involve a provision, criterion or practice which puts workers of a particular age or age group at a disadvantage. And so the practice itself might appear neutral, but when you look at it and you sort of delve down into the detail, it puts people in a particular age or age category at a disadvantage. And we've shown with the little arrow here that there has to be group and individual detriment, so the individual bringing the claim would need to show that their provision would or could put them at a disadvantage. So examples in a pension scheme context, just to bring it to life for you all, an example of direct discrimination might be a provision that simply says that no benefits will be provided to an individual after age 65. So that's a provision that is clearly linked to that person's age. An example of indirect discrimination might be something where you have higher pension benefits for people who joined the scheme before a certain date. So whilst that doesn't seem to be linked to age, there might be many older workers who joined before a certain date, and therefore younger workers might be put at a particular disadvantage by that provision. And uniquely, unlike the other protected characteristics that are contained in the Equality Act, such as race, sex, religion, for example, in the case of age, both direct and indirect age discrimination can be objectively justified. And what we mean by that is it won't be unlawful if it can be shown that the treatment or the provision, criterion or practice is a proportionate means of achieving a legitimate aim. We're going to have more on that later from Liz, but just to flag that for age, both direct and indirect can be objectively justified. So moving on to some of the other acts that are prohibited under the Equality Act, it's important not to forget about those. And we have on here harassment. And this prohibits someone harassing another, which means essentially engaging in unwanted conduct relating to their protected characteristics. So here, unwanted conduct related to their age. And that conduct has the purpose or effect of violating their dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. And you might think, well, where does that actually sit when it comes to pension schemes? Because surely you can't have harassment there. But think, for example, about a particularly aggressive benefit provider who is harassing or chasing people of a particular age to find out their estimated retirement date, for example, or where there's a benefit change exercise which is targeted at a particular age group. If that was done in a fairly aggressive manner, kind of persuading people to try and make a decision, then that could potentially constitute harassment. And the final thing I want to cover is victimisation. And victimisation occurs where an individual is subject to detriment because they have done, intend to, or are suspected of intending to carry out a protected act. So the most obvious one here would be where somebody has brought or is threatening to bring an age discrimination claim. If that person is then treated less favourably because of that, that would constitute victimisation. So if, for example, you decide to withdraw an offer that you've made to that person, or not give consent to a discretionary benefit or something like that, that could constitute victimisation. So with pension schemes in particular, direct and indirect are probably most likely to be relevant, but we flagged the others because they could occur, so it's important not to forget about them. And Section 61 of the Equality Act inserts a non-discrimination rule into occupational pension schemes, which essentially says that direct, indirect harassment and victimisation are all prohibited. And that applies to responsible persons, which includes the trustees and managers of the scheme, as well as the employer whose employees are members.
Okay, so thanks for that, Ruth. We're just going to go for our first poll, and thanks for those on the line who very gamely completed the poll the first time round when there wasn't any sound. That's really appreciated, but hopefully now there's a bit of context to it with the actual audio feed. So what we're asking you is our 10th anniversary special question. When did you last do an age discrimination audit of your pension scheme provisions? So there's a few options there. Around 2006, so 10 years ago when the legislation first came in. Second option is within the last 5 or 10 years, within the last 1 or 2 years, never, or I don't know. So we're just going to push that out to you to see what you think, get some responses from the audience that stayed with us. Thanks for everyone who has stayed on the line. Like we said, we'll be giving you a full version of the presentation as a recorded presentation, just in case you do need to dial off at the usual time that we were supposed to be finishing. Fortunately, the responses that are coming in are a lot healthier than the first time round, which suggests that everyone who's stayed with us is now able to hear the presentation, which is always helpful. We'll just give that a few more seconds before we push the answers out to everyone so you can see what people have actually been saying. So it's quite interesting there that there's a lot of people who either haven't done an age review or aren't aware of an age review having taken place, and that contrasts with about a third of the audience who've done one in the last 1 or 2 years. So maybe it's something that's either something that you've looked at recently and do frequently, or it's just something that hasn't come up and maybe something for organisations to think about.
Thanks, Ian. So we've looked at what the age discrimination legislation says in terms of what's prohibited, and now we're going to turn to exemptions. So there are a number of exemptions that apply to pension schemes, but here on this slide we show one that applies to benefits more generally, and that's the length of service exemption. And this essentially says that it's not unlawful or an age contravention to place somebody at a disadvantage where the disadvantage is because they have a shorter period of service with the employer than another. And in the case of an occupational pension scheme, this might apply to a rule or practice or decision regarding admission terms, or the accrual of or eligibility for a benefit, for example. Where the length of service is more than 5 years, the employer needs to show that there's a legitimate business need for the different treatment. And that legitimate business need might include encouraging loyalty or motivation, or rewarding experience of the people with the longer service. And we then come on to pension-specific exemptions. So clearly pension scheme benefits are inherently age discriminatory because the whole structure of pension schemes is that they pay out benefits at a certain age for people. And the government recognised this, so they did introduce a number of exemptions to the overall principle that you can't discriminate against individuals on the basis of age. And I've listed some of these exemptions on the next slide. And it's important to say that this list isn't exhaustive, so there are just a few here, but if you want to check whether or not a particular rule or provision that you have fell within the exemptions, I would suggest going back to the order that we listed on the previous slide. But we have things, for example, like minimum or maximum ages for admission to a scheme, and just worth flagging that having a maximum age for joining an occupational pension scheme is an exemption, but this doesn't extend to personal pension schemes. Having minimum ages for drawing benefits from the scheme. Another one maybe worth highlighting from this list is age-related contributions to money purchase schemes. So that's under a money purchase arrangement, it is possible to have different rates of member contributions according to age bands. But where that happens, the aim needs to be to set those different rates so that you're equalising the amount of benefit that people will get when they come to retire. So some actuarial input is normally needed on that front. And the final thing I want to say about this slide is this is the age discrimination legislation, but clearly there are other forms of legislation that are out there for pension schemes and that would need to be complied with, such as auto-enrolment legislation. So it's important to do an audit of the scheme from that perspective as well as looking at the age discrimination angle. And whilst there are exemptions that apply to pension schemes, not everything is covered by an exemption. So having an age at which the scheme stops accrual for particular members is not covered by an exemption. So saying that accrual cuts off at normal pension age of 65, for example, not an exemption to cover that particular scenario. Golden rules, which generally refers to rules where a member may receive a reduced benefit or an unreduced benefit once they've reached a combined minimum age and length of service, is not covered by an exemption. Whilst there's an exemption that might cover those two things separately, where they're in combination, it doesn't fall under the regulations. And having a cut-off age for death benefits paid from the scheme is not covered by a specific exemption, but there is an exemption that applies to insured benefits, which we will come on to look at later. So where does that get us to, and what questions should you be asking if you are doing an age audit of your scheme or looking at a particular rule or practice? Well, the first question you should be asking is the rule or practice potentially age discriminatory? And remember there, consider both direct and indirect age discrimination, indirect being sometimes a lot more difficult to spot. If the answer to that question is yes, then go on to look at whether or not the rule or practice is covered by a specific statutory exemption. And if the answer to that question is no, then you'll need to go on and look at whether or not it's capable of being objectively justified. And Liz is now going to come on to look at what we mean when we talk about objective justification.
Thanks, Ruth. So yes, if an employer or trustee can't shoehorn a practice, provision or measure into one of the specific exemptions, it must successfully show objective justification in order to defend itself against an age discrimination claim. And the concept of objective justification originally came from indirect discrimination case law, which was in place in respect of the other protected characteristics, for example sex discrimination, before the introduction of the age regulations in 2006. An objective justification requires an assessment of whether the treatment or the practice criteria or provision complained of is a proportionate means of achieving a legitimate aim. Essentially, this is about persuading a court or tribunal that judged objectively the act is justified. In shorthand, this is about the end justifying the means. So how should an employer or trustee approach constructing a defence to age discrimination? The first step is to establish a legitimate aim or aims. And I generally will be referring here to the aims of the employer, which the trustees then may want to be seeking to rely on. And for indirect age discrimination, establishing legitimate aims leaves a large degree of flexibility open to the employer. Legitimate aims are not defined in the legislation, but they can potentially be any reason of the employer or trustees which justifies the measure or the practice which gives rise to the alleged discrimination. So good examples would be rewarding loyalty, encouraging motivation, rewarding experience, and the facilitation of employment planning, so for example succession planning. The employer doesn't have to establish the legitimate aims at the time it applies the PCP, the practice provision criteria, or the measure. It can do retrospectively, so looking back, and this might need to be relied on if you're looking at pension scheme rules that were brought into place 20 or 30 years ago and you're trying to establish why they were put in place in the first place. But generally it's preferable for an employer or trustees to attempt to establish the legitimate aims at the time the provision is introduced. And it's also helpful to have evidence to show why you've got those legitimate aims. So we've got a really good example of this that's come out in a case law from the last couple of weeks, where the ECJ has made a decision involving the Basque Police and Emergency Service Academy, which required that applicants for the role of police officers in the Basque region are aged under 35 at the time of their appointments. And an age discrimination claim was brought in relation to this cut-off age. And the European Court accepted that on the facts, the Basque Police had compelling evidence to justify the legitimate aims sitting behind the policy, including that forecasts showed that the demographics of the current Basque police force would result in more than 50% of police officers being aged between 55 and 65 years old by 2025, which presented a major issue to the police, given the demanding nature of the role. It's also important to note that cost grounds alone cannot form a legitimate aim for discriminatory treatment. This was originally established in sex discrimination cases in the 2000s, and it accords with the fundamental principle that employers cannot justify continued discriminatory treatment, so for example paying women less than men, simply because it would be prohibitively expensive to uplift women's salaries to that of their male counterparts. And this has flowed through to the age discrimination cases that we've seen. A good example being Woodcock. This was a case involving a chief executive of the North Cumbria Primary Care Trust, and he was in the process of being made redundant, and the PCT realised that they needed to act more quickly in order to issue the notice of dismissal to Mr Woodcock, because if they didn't do so very quickly, he was going to reach his 50th birthday, at which point he would be entitled to enhanced pension benefits. And in this case, the Court of Appeal was willing to accept that whilst costs were a significant factor in the PCT's decision to dismiss Mr Woodcock, there were other factors, so the plus element of a cost plus rationale was shown, including the fact that the PCT was going to make Mr Woodcock redundant in any event, and so the plus element was actually the act of dismissal for Mr Woodcock. The second step for employers in terms of justifying an act is demonstrating proportionality, because the case law indicates that it's relatively easy for an employer to establish a legitimate aim or aims for indirect discrimination, but then the employer must show that the actions or measures in place are a proportionate means of achieving the employer's legitimate aim or aims. The directive talks about the act being both appropriate and necessary, so essentially the means chosen to meet the objective must go no further than is necessary. And I always think of this as being a balancing act between the legitimate aim of the employer and the impact on the employee or the member. It's going to be much harder for the employer to show that the means adopted to achieve the aim are proportionate in the circumstances if the impact is very heavy on the individual. The case law around direct discrimination has really evolved over the last 10 years. The legislation is ostensibly indicates that the test for justifying both direct and indirect age discrimination is the same. But the courts have interpreted the two tests differently, depending on whether it's direct or indirect discrimination. And this very much flows from the Framework Directive and the European Court's interpretation of what the intent of the directive originally was. So where we've got to is that the European Court, agreed to by the Supreme Court here, have agreed that whilst the tests of direct and indirect discrimination in the Framework Directive are broadly the same, satisfying an allegation of direct discrimination must be in pursuit of legitimate social or employment policy aims. They can't be aims specific to the employer in question, such as cost reduction or improving competitiveness. So I think you need to bear in mind that employers essentially have a higher burden of proof in showing a social policy aim where you're faced with an alleged act of direct discrimination. And what about the trustees of pension schemes' ability to objectively justify? Well, this remains relatively untested despite having 10 years of age discrimination law in the UK. And I think for the trustees it can often be difficult to know if there has or will be age discrimination, because it might depend in part on the demographics of the employer's workforce and how, for example, pension scheme rules might apply to people. But if trustees have concerns, I think that the first instance would be to attempt to piggyback essentially on the employer's objective justification. So ask the employer what the reasons were for the, for example, pension scheme provision or the practice which might be age discriminatory, and ideally seek either a comfort letter or, even better, would be a deed of indemnity from the employer in relation to the age discrimination concerns that the trustees have. And we've certainly seen that in practice in the pensions team here at Gowling. So what about age discrimination 10 years on in terms of common issues? Well, when the age discrimination legislation was first introduced, it was possible for employers to fairly dismiss employees aged 65 and above as a retirement. In 2011, this default retirement age was removed, meaning that unless an employer is sufficiently confident it can keep in place an employer-justified retirement age, which in our experience is rare, there's no cut-off age at which it should be assumed that employees retire. And if an employee does want to dismiss an older employee, it must follow a fair process and have a fair reason, as you'd expect for anybody employed by you. But what this means, therefore, is that some thought needs to be given to the treatment of older workers who might remain in the business for much longer than would have previously been the case. The main principle here is that you need to try and provide for either continued accrual of benefits, so for example if they're in a defined benefit scheme, allowing them to continue to accrue benefits beyond, for example, age 65. There is a limited exemption in the age exemptions order which provides that you can have an overall maximum accrual, for example 40 years service, at which point somebody stops accruing benefits. But even if somebody has stopped building up their defined benefit pension and, for example, is taking that pension, the employer needs to think about what kind of other benefits it still continues to provide. And we often see that employers might choose to offer defined contributions benefits for employees who have essentially maxed out on their defined benefit pension schemes. And that also makes sense in relation to the automatic enrolment provisions, as Ruth alluded to, and the fact that you still need to make sure that you're complying with automatic enrolment for older people if they qualify under the automatic enrolment provisions. We've also seen recently employers looking at whether they want to ensure that there is a scheme rule requiring employees to leave service before they take benefits. But some care is needed here because it depends on the drafting of the scheme rules as to whether you can justify introducing that kind of rule if you don't have that at all already. Scheme closure can also be a particular issue. And although there is also exclusion in relation to the ability to close the scheme to new entrants, there isn't a wholesale exclusion if you're simply closing a scheme down to future accrual across the piece. And what we tend to see in practice is that you might get allegations of age discrimination from older employees, I think possibly because they are more live to the potential impact on not being able to build up the full pension that they were expecting. But actually, I think a more realistic and successful claim can be brought by younger employees, arguing that the closure disproportionately impacts on them because they won't be given the opportunity or time to accrue the full, more generous pension which would have been available to them had they been older. And so this is a really important one to bear in mind if you are dealing with scheme closure and how you might address that situation. Dumbreck and Ofcom was a helpful case around this, because Mr. Dumbreck, amongst a number of other employees employed by Ofcom, was subject to a change of pension scheme structure, moving from defined benefits to defined contribution pension benefits, and Mr. Dumbreck brought an age discrimination and unfair dismissal claim. And the Employment Tribunal said that this was not age discrimination the decision available to Mr. Dunbreck was not necessarily related to age, and actually he suffered no greater disadvantage than younger employees as a result of the switch from defined benefit to defined contribution. If anything, the tribunal recognised that younger employees were more likely to be impacted. We've also seen that the structure of certain liability management exercises can be problematic in terms of using very hard age cut-off dates in terms of the structure of the exercise. And employers are increasingly using these types of exercises to manage their liabilities of defined benefit pension schemes, particularly when they've gone through the closure exercise already. So, for example, an enhanced transfer value exercise would be offering members the ability to take their benefits out of the defined benefit pension scheme, so reducing the liabilities for the employer and the trustee. But sometimes these exercises can have hard age cut-offs, for example age 55, and given that that is specific to an individual's age, I think that would be very difficult to justify if there was an age claim brought as a result, particularly given that direct age discrimination claims require a social policy justification, which I think would be very difficult for an employer to demonstrate. It would be preferable, I think, for the ETV to be structured on a cohort of members, for example, those with the highest liabilities in the scheme. And it wouldn't avoid age discrimination claims altogether, because there still might be certain individuals who are prejudiced under age discrimination legislation, but I think it's much less likely to result in obvious age claims arising. Similarly, pension increase exchange exercises, whereby groups of members are given the opportunity to forego the non-statutory increase in part of their pension for a one-off uplift, might also create age discrimination issues, particularly because, on the one hand, members should be treated equally, regardless of age in these kind of exercises, but it has to be balanced against safeguarding concerns for vulnerable members, for example, contacting those aged over 80. And that goes back to the point that Ruth mentioned earlier in this webinar around not badgering effectively older people and avoiding risks of harassment claims.
Okay, thanks for that, Liz. We've got our second poll question, very much feeding from what you were just talking about in terms of maximum cut-off ages. So we're asking that if you provide insured benefits to employees, for example life assurance, do you have a maximum cut-off age for the cover that you provide? And there's 4 options there. Yes, the higher of 65 or state pension age. Yes, an age other than 65 or state pension age. No, or I don't know. So I'm just going to push that out to the audience now, and if you can select any of those that apply, that would be great. So we're just getting in a few responses now from people. Thanks for bearing with us today. We're obviously aware that we're running over the originally promised time. If people do need to drop out for other commitments, then we'll be providing the recorded version of the webinar together with a transcript, so you'll be able to catch up on the last few minutes. And of course, just as importantly, any questions, if you want to send those in, we'll deal with those in the webinar or offline. So just finish pushing that out to the audience now. There's a big chunk of people there that either don't have a cut-off or do have a cut-off, and it's an age higher than 65 or state pension age, and a few that still have the state pension age or 65, whichever's the higher. So some interesting results there. There's obviously a range of different practices from people. So going back to the presentation.
Thanks, Ian. Well, yeah, in this final section, we're going to look at insured benefits and a specific exemption that covers those. Just a little bit of background to this exemption. It was brought in when the statutory default retirement age was abolished in 2011. And I think the reason for that was that employers had a concern that if there was no age at which people had to retire and leave the workforce, they could come under considerably hefty premiums from insurers if they had to continue to provide insured benefits for a increasingly ageing workforce. So there was a specific exemption included to address this. And that exemption is contained in Schedule 9 of the Equality Act. And it essentially says that it's not an act of discrimination for an employer to make arrangements for the provision of insurance to or in respect of an employee ending when the employee reaches the greater of age 65 or state pension age. Importantly, unless the employer is an insurer, the exemption will only apply where the insurance is provided by way of an arrangement with a third party. So it won't apply to employers who self-insure, and they would therefore need to show that stopping cover at a particular age was objectively justified. There's also a question about whether or not the exemption covers trustees, because it does only refer to employers, so trustees might have to look to piggyback onto the employer's defence. That's not really been a tested area yet. And the exemption does only apply to the cut-off where it's the greater of age 65 or state pension age. So bizarrely wouldn't cover actually a more generous cut-off age such as age 70. So again there you need to be looking at objective justification. So questions that trustees and employers should be asking themselves on insured benefits. Number one, again, is the rule or practice potentially age discriminatory? So is there a cut-off age, for example? Number two, does it fall within that statutory exemption that we've just covered and given the reference for? And if the answer to that question is no, is it capable of being objectively justified? So I'm just going to run through a few cases on this that may be helpful. First case, Whittam and Capita Insurance Services. Mr. Whittam received PHI, so that's private health insurance benefits, which stopped when he reached age 55, and he hadn't been allowed to join a more favourable PHI scheme arranged while he'd been off, which would have entitled him to those benefits up to age 65, and that was because the insurance company wasn't prepared to indemnify him under the best policy unless he was actively at work, which he wasn't at the time that new insurance arrangement was entered into. And he brought claims for direct and indirect age discrimination and was successful in both of those claims. Another case which is not actually to do with pension benefits but I think is helpful in making a particular point, the case of Foreman and Oasis Taxis. And in this particular case, two individuals eventually after a retender were due to be employed by Oasis Taxis, but Oasis Taxis said it couldn't employ them because the insurance policy that it had for drivers only covered employees up to age 69, and so these two individuals who were both over that age were not covered. And the Employment Tribunal held that this was indirect discrimination and put both of these individuals at a disadvantage. And importantly, the Tribunal, in its decision, noted that Oasis Taxis had made no efforts to seek insurance for the individuals other than to make a single phone call to its insurance broker. So I think what this case says is essentially that you need to shop around really for your insured benefits and not just assume that what your insurer is telling you is commonplace in the market is necessarily true, and show that you have made some effort to provide cover for your employees or your members. And the final case that I'm going to cover on insured benefits was Smith and Gartner, which is actually a case from 2015. Ms. Smith received payments under a disability plan from May 2003, and at the time she started receiving those payments, the company's retirement age was 60, and when she reached age 60, her benefits under the plan ceased. And she brought claims for unlawful deduction of wages and direct age discrimination. The claim was struck out at tribunal, and the Employment Appeal Tribunal upheld that decision. And the reasoning was that the company's obligation here was to provide insurance, and that was the obligation that it had set out in the contract. It didn't actually have the obligation to pay out the benefit. So the employer here had complied with its obligation, and the cessation of benefits when claimant turned 60 was consistent with the rules of the insured scheme and didn't amount to direct age discrimination on the part of the employer. And the tribunal also noted that any such claim would have needed to have been brought against the insurer. Important to just note that the fact here occurred prior to age discrimination legislation and insured benefits exemption coming into force, although question whether or not that would have changed the decision because it was to do with a contractual entitlement to insured benefits up to retirement age, which at the time was age 60. So where does this leave us? Well, I'm going to pass over to Liz to wrap this all up for us.
Thanks, Ruth. So where does this leave us? Well, I think the first point that's hopefully come out is to take care around objective justification, particularly direct age discrimination. The case law around this has really moved on since the age discrimination legislation came in 10 years ago. In particular, ensure that thought has been given to benefit provision for older workers. I think this is an area which we haven't seen the last of. I think it's going to become more and more of an issue over time as the demographics of our country just moves gradually upwards and people remain in work for longer. Similarly, the structure of liability management exercises needs to be thought about. I think this is a relatively unthought of area, but we've certainly seen that liability management exercises really sometimes have some screaming cut-offs which could create problems. And trustees' potential exposure does still remain relatively untested, so I think we'll see in the next few years the boundaries of that being explored more. So what should you be doing? Well, we definitely recommend an age audit of pension and benefits to identify any rules or provisions which might be problematic. As Ruth mentioned, insured benefits still remain a real problem, and so an audit of your insured benefits provided to employees, including regular monitoring of what's available in the market, is a good idea because this is also an area that's changed over the last 10 years. I'd also say think about age discrimination issues early on when it comes to any kind of benefit change exercises, be that scheme closures, liability management, or just benefit changes more generally in terms of how that might disproportionately impact on particular age groups. So that's all I was going to say on conclusions and what we were going to say more generally. And I'll just hand back over to Ian.
Well, thanks very much for that, and thanks hugely to the audience that has stuck with us whilst we were just powering through some technical issues to start with. Just going to have time for just a couple of very, very quick questions. What we're going to do is respond to other questions offline, so if you have asked something that doesn't get answered, then we will be dealing with that. But there's a really interesting one that's come in saying we're finding it really difficult, if not impossible, to get insurance or life insurance for employees who are aged over 70. What should they actually be thinking about doing in those circumstances?
Thanks, Ian. Well, yeah, I mean, that can put an employer in a difficult position, and that's partly because the wording in the exemptions that I covered earlier is drafted so narrowly, so it only applies where the cut-off is 65 or state pension age, and actually if you're more generous, you don't fall within the exact wording, although it's hoped that if the courts or tribunal were to look at your provisions, they would recognise that you're providing something more generous. I think it would be important for an employer in that situation to show that they had shopped around and looked for alternative provision, and then look at their objective justification, so their reasons for having that particular cut-off age and whether or not they were able to justify it. They could also think about self-insurance, but I think that would be potentially very expensive. So it's hoped really that the insurance industry will just keep pace with longevity and working patterns of employees, so that it doesn't become too much of an issue for employers.
And it's a developing piece, isn't it? It's something that we're seeing developments on that carries on. Speaking of development, we have a question that as lawyers we're almost obligated to ask at the moment or consider. There's a question that's arisen about what would the impact of Brexit be. So this is definitely something that's coming up across the piece on employment and pension law issues. Liz, what do you think of that?
Well, as I mentioned, the Framework Directive required the member states to introduce age discrimination legislation, and those provisions have now been introduced in the UK by primary and secondary legislation. So there would firstly have to be significant steps taken to remove those provisions. So let's assume the Equality Act stays for now, that's not going anywhere for the time being. And actually, although we live in interesting times politically, I still think that it's unlikely that there would be a push to remove that sort of legislation in future. I think the discrimination laws, amongst other key protections for workers, are, at least for now, relatively accepted by politicians of all persuasions in broad terms. And that said, I think it's entirely possible that as we move out of Europe, the UK courts might move away from the European jurisprudence that we've seen on this. So I referred to a number of European decisions which have impacted on how we now look at age discrimination. And so the UK courts might well take a different approach to, for example, direct page discrimination if they didn't always have to refer back to what was being said at the European level.
Yeah. Okay. Well, that's all we've got time for with this. I'd just like to have a big thank you for our presenters Liz and Ruth, and especially to our audience. We look forward to welcoming you onto the next All About Age webinar in 2017. There is a feedback questionnaire that will be coming on your screens soon. You can also download information such as the slides in the download tab, and more importantly, we're going to be putting a recording of the webinar on the website, and we'll let everyone know when that's available so that you can look at that in your own time or send it on to anyone who you think might be interested. So